Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about lawyers' charter rights. Cases that should have gone to the Supreme Court of Canada, but didn't. You might not think it, but lawyers in some respects have charter rights, and this was the case for Sharon Fox, a lawyer who was ultimately charged with obstruction of justice. She was representing a client who was subject to a wiretap. The wiretap prohibited the police from actively listening to conversations that she had with her client who was under investigation. Those conversations were recorded, but they could not be heard without a court ordering that the conversation could be listened to. For example, if the conversation were not about the giving or receiving of legal advice or something that was not covered by and protected by privilege. A judge could make that determination, and then the police could use the recording if it was helpful to the case. In this case, Ms. Fox's conversations with her client were recorded in a circumstance where she was advising her client that somebody else, an associate, had been arrested and that likely a warrant would be executed on his place in the future. Essentially, the Crown's argument on the interference or obstruction of justice was that she was warning her client so that he could dispose of anything that might get him in trouble should a warrant be executed. And this case raised a very important issue, which was Ms. Fox's charter-protected rights. While the wiretap was validly authorized against her client, because the police went too far in listening to the recording, because a portion of the recording had been actively listened to by a civilian employee, and then a judge had unsealed the recording to allow it to be listened to, which ultimately led to the charges being brought against Ms. Fox, she argued that her right to privacy and her client's right to privilege had been violated, and that because privilege is a solicitor-client relationship, it functions effectively both ways. That Ms. Fox had the right to expect that the conversation would be privileged when she contacted her client. So not only was it a violation of her right to be free from unreasonable search and seizure and her privacy rights, but it was also a violation of Section 7 rights belonging to the lawyer in the context of privileged communication. And this case is such an interesting interpretation of privilege in the context of a charter right where privilege is being asserted not by the person who is affected by the loss of privilege, but instead by the lawyer who claims to have privilege over the conversation. This happens very rarely in our legal system. And it would have been a great opportunity for the Supreme Court of Canada to really make an interesting ruling on the bounds of privilege and who enjoys privilege. Because arguably, if she can assert privilege over the conversation as a shield to a potential criminal charge, arguing that it violates her Section 7 charter rights, then a lawyer could potentially assert privilege in other contexts where a client, for example, wants to say something negative about the lawyer or the relationship, or say something about the advice that the lawyer gave. And the extent to which this ruling could potentially be used to open the door to lawyers potentially protecting their bad conduct, as Ms. Fox was allegedly attempting to do in this case, potentially attempting to protect their bad conduct from rebuke or from discovery, but also to lawyers essentially being able to assert privilege in circumstances where somebody else may be argued to have waived it or the privilege shield may be arguably pierced. It's something that the Supreme Court of Canada has really never ruled on before, and it would be very interesting to see how they would rule on this issue. It's unfortunate that the Supreme Court of Canada didn't get into really the way that lawyers enjoy charter rights in relationship to their clients in criminal investigations. And unfortunately, it probably won't be any time in the future that we're going to see a situation where the Supreme Court of Canada is going to have an opportunity to consider such a nuanced and interesting legal issue in the future. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.